Good afternoon, and you're all very welcome to this TRP forum. I'm Dr. Danielle Petherbridge, Director of the UCD Centre for Ethics and Public Life, and on behalf of our co-hosting partners, the Centre for Cross-Border Studies in Armagh, represented here on the panel by Anthony Soros, and the Institute of Irish Studies at Liverpool University, represented here on the panel by Gerard Diver. It is a pleasure to welcome you to this online forum to discuss a proposed Truth Recovery Process, TRP. We're also joined here on the panel by Associate Professor Catherine O'Donnell from the UCD Centre for Ethics, who is also a moderator for the event today. First, I'd just like to say a few words about how the event will run. The forum will be chaired by Mr. Justice Richard Humphreys, and we'll begin with presentation of legal opinion on the compatibility of the Truth Recovery Process with the European Convention on Human Rights. Responses will follow from three invited respondents, Bryce Dixon, Pat McCartan, and Alan McBride. At the conclusion of the responses, we will take questions from you, the audience here today. Please note that questions need to be forwarded to the moderator using the question and answer function, the Q&A function, at the bottom of your screen. And just to point out, you have the option to ask your question anonymously or to include your name. Please note that this event is being filmed, so if you do not wish your name to be read out with your questions, please use the anonymous function. Now to begin proceedings. I would first like to introduce the representatives for the Truth Recovery Process on the panel today, who will turn their cameras on one at a time as I introduce them, who will be able to address questions at the end of the forum and will provide some background to the Truth Recovery Process. As part of the panel, we have Porrig Yates, who is Secretary of the Truth Recovery Process. Porrig is a journalist and historian. We also have John Green, who is a history graduate and has been a practicing accountant in financial services for over 40 years. He currently chairs Festina Lente Enterprises, which assists the marginalised in society. He's a former chair of Glasnevin Trust and is a board member of the Truth Recovery Process. And now I would like to introduce Liz McManus, who is a former TD for County Wicklow, former deputy leader of the Labour Party, and Minister for State for Housing and Urban Renewal. She is an award-winning novelist and board member of Pen na hÉireann. By way of providing some background, Liz McManus will now say a few words about the Truth Recovery Process. Thank you, Liz.
Thank you very much, Danielle, and hello to everybody. Despite concerted efforts by politicians, officials, lawyers, NGOs, and community leaders, the complex justice issues arising from the Northern Ireland conflict remain unresolved. In this situation, the peace agreement has evolved into a political truce rather than a resolution of past conflict. So we're offering the Truth Recovery Process, TRP, as an alternative to those who wish to avail of it. It is an extrajudicial approach to achieving reconciliation on the facts for victims, survivors, and former combatants alike. We regard this as a necessary first step towards healing past harms. Without agreement on the facts, there can be no basis for agreement on anything else. Unfortunately, the judicial approach adopted to date is cumbersome, time-consuming, expensive, and often re-traumatizes victims and survivors. Far from leading to honest debate or full disclosure, let alone reconciling the parties, a trial often has the opposite effect. Its objective is to determine guilt or innocence of a criminal offence. Every acquittal and every conviction is therefore viewed as a victory or defeat for one side or the other. Thanks to FLAC's Public Interest Law Alliance, Michael Lynn, SC, and Kayla Varley, BL, we have a legal opinion to demonstrate that the TRP is compliant with Article 2 of the European Convention on Human Rights. The TRP proposes a system of conditional amnesties for former combatants that would encourage them to engage with victims and survivors through a mediation model operating under the auspices of a reconciliation commission headed by a mutually agreed international chair or two senior members of the British and Irish judiciaries. The chief executive of the commission and its operational wings would be answerable to its chair or chairs. The commission itself will have two operational components. One, a truth recovery unit. In a Northern Ireland context, this would replace the historical investigations unit. Two, a justice facilitation unit. In a Northern Ireland context, this would either replace or be incorporated into the Independent Commission for Information Retrieval. The TRU would collect and verify information, not for the purposes of preparing a prosecution, but to achieve the fullest possible disclosure to victims and survivors. The Justice Facilitation Unit would provide a discrete mediation process and design protocols that would allow victims and survivors and former combatants to engage with each other. This would not necessarily require them to meet if the victims and survivors did not wish to do so, but it would be a condition of the amnesty for former combatants to meet with victims and survivors if required of them. We believe this model is far more conducive to establishing the full facts in each case and achieving some degree of reconciliation between the parties than the legal arena is. The process would take place behind closed doors, and full public disclosure would only take place with the mutual agreement of all the parties, in which case they would be encouraged to become advocates for the truth recovery process. This process, the truth recovery process, grew out of 3 years of discussions between former combatants, victims, survivors, and academics. It springs from a realization that more roadmaps are needed than those already provided in the 1998 agreement if we are to navigate out of the minefield of legacy politics and achieve genuine reconciliation in these islands. It's not possible to go through all the details of the process in this brief introduction, but we will try to answer your questions in the course of the webinar, and the full text of the process is available on our website. Thanks, Danielle.
Thank you so much, Liz. It is now my great pleasure to introduce the chair of this event, Mr. Justice Richard Humphreys, who will lead the proceedings today. Justice Humphreys holds a BCL 1988 and an LLM 1989 from NUI UCD and a PhD from the University of Dublin 2007. He is the author of 4 books: Index to Irish Statutory Instruments 1988, Countdown to Unity, Debating Irish Reunification 2007, Beyond the Border, The Good Friday Agreement and Irish Unity After Brexit 2018, and Reconciling Ireland 2021. He's also the author of various book chapters and articles in legal journals and general publications. He was a practicing barrister from 1997 to 2015 and was appointed as a judge of the High Court in 2015. He was appointed to the Superior Court's Rules Committee in 2020. We're honoured to have you here today. Thank you so much, Justice Humphreys, for chairing the event today. I will now hand over to you. Thank you.
Well, I was glad to accept an invitation from my alma mater, UCD, to take part in this event, and in particular the Centre for Ethics in Public Life in conjunction with the Centre for Cross-Border Studies and the University of Liverpool, all of which are doing fantastic work And I want to pay tribute to the work of all three institutions that are sponsoring this afternoon's discussion. So as everyone knows, all parties on the two governments agreed to a particular approach to legacy issues in the Stormont House Agreement, which was later followed up by a bilateral treaty between the two governments, which has not as yet been ratified. The UK government then proposed an alternative approach, which essentially involved an amnesty. And again, as you know, that was unanimously opposed by all parties, North and South, and by the Irish government, as well as being opposed by groups representing survivors and relatives. And the Irish government in particular made the point that they were of the view that the British government's approach would raise a serious issue about possible breach of Article 2 of the European Convention on Human Rights. Now, an alternative proposal, more in the space of a conditional amnesty at the risk of over-summarisation, has been proposed now by a private grouping, the Truth Recovery Process. And that's going to be the focus of some of our discussions today. Now, needless to say, any deviation from Stormont House, whether that is the British government approach or any other variation, will raise significant legal issues, particularly under Article 2 of the ECHR. The main focus of this afternoon's event is going to be the legal issues around the TRP model, and we will also no doubt find room to go on from there to discuss some of the pros and cons of the various models concerned. I need hardly say that the three institutions sponsoring the event and myself are here to facilitate discussion and debate, and we're not endorsing any one or more of the particular options, and indeed one doesn't have to endorse or advocate any particular option to see a value in the discussion of the implications, and particularly the legal implications. Now, we must also recognise the tremendous sensitivity of these issues and the suffering of the victims, survivors and relatives, which is the background against which any debate and consideration of these issues has to take place. As Liz mentioned there, the legal opinion was very generously prepared by Learned Counsel under the Public Interest Law Alliance scheme, which is a wonderful scheme whereby non-governmental bodies and organisations can request essentially free legal opinion and advice. And that's a very valuable service, and it allows both legal advice to be provided, and it also allows the bar to contribute something by way of public service above and beyond the normal duties that fall on barristers. So on that note, I'd like to start by introducing Michael Lynn, Senior Counsel, who will be the first of the two speakers to present the legal opinion on the compatibility of the TRP with the European Convention on Human Rights. Michael is a graduate of Trinity College Dublin, and he does something relatively rare these days, which is to practice across the spectrum, both in criminal law and civil law. He has had a particular focus in his practice on human rights and on sort of pioneering human rights issues. And I've been given a list of the most high-profile cases Michael has been involved in. Even this month, he was involved in a very high-profile criminal matter, successfully leading for the defence. He was involved in a challenge to the report on the Commission investigation into mother and baby homes. And then he represented a group of public figures led by Roisin Shortall in the challenge to the religious declaration relating to membership of the Council of State and the presidency, which will no doubt remain a topic of discussion, notwithstanding the procedural issue on which it was decided by the European Court of Human Rights this week. Michael lived in Fermanagh in the late 1960s and 70s and went to school there, where his father was a Church of Ireland clergyman. So he is, in terms of his personal history and knowledge, he's very much versed in many of the complexities and nuances of relationships on the island. He has been an incredibly active senior counsel and a very helpful colleague when I was a barrister, and certainly a very impressive advocate looking from my side of the courtroom where I am at the moment. So on that note, can I call on Michael Lynn, SC?
Thank you, Judge Humphreys. Far too generous. I won't dwell on that. Thank you very much, and good afternoon to everybody. And thank you to the organisers for inviting me and Kayla to participate. And At the risk of repeating something that Judge Humphreys said, I do want to underline before I say any more that myself and Kayla were approached to see if we would, through this Public Interest Law Alliance scheme, offer an opinion for the truth recovery process. And we were very happy to do that. And it's important that I underline that we're not advocates for the scheme. We're not part of the campaign group. We're completely independent. And unfortunately, the only thing we have to offer is a legal opinion. And the opinion may be wrong, but it's a legal opinion. We have no idea how the proposal would work in practice, whether people would support it, buy into it. That's way beyond our remit. We were asked to advise whether the proposal is compatible with Article 2 of the European Convention on Human Rights. Now, I hope to be only about 10 minutes because I see we have more than 70 people online and we only have an hour and a half. And I think contributions from everybody possible, it would be welcomed rather than me taking up too much time. And Kayla's going to follow me, and I think Kayla's going to aim to be about 10 minutes. But because we're remote, I have prepared several slides. We were asked to examine whether the proposal is compatible with Article 2. And I want to just give a very brief outline of what Article 2 of the European Convention is and states, what duties arise from it that are relevant to the proposal. And then I want to focus on what is probably the primary issue, and indeed Judge Humphreys referred to it, the conditional amnesty aspect. So you'll see there, Article 2, it's the right to life, and the first paragraph, everyone's right to life shall be protected by law. And then no one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. That's paragraph 1. Then paragraph 2 is the paragraph which sets out what exceptions there may be when it comes to the taking of life. And you will see it must be no more than absolutely necessary. And then there are 3 categories: in defense of any person from unlawful violence, in order to effect a lawful arrest or to prevent the escape of a person lawfully detained, in action lawfully taken for the purpose of quelling a riot or insurrection. So it's a relatively short article. And what's important is what duties and obligations arise on a state that has signed up to the convention. And if we can go to the next slide, please, Kayla. I've picked out 2 of the duties that are absolutely key to the debate we are having this afternoon. Firstly, you'll see there's a duty to protect life, an obligation on states. And part of this duty places, quote, a primary duty on the state to secure the right to life by putting in place an appropriate legal and administrative framework to deter, now that's an important word which I'll come back to, the commission of offences against the person, backed up by law enforcement machinery for the prevention, suppression and punishment, again a word I'll have to come back to, of breaches of such provisions. So just to pause there, that's a duty to protect life, which places this primary duty on states to have a legal framework that investigates and punishes perpetrators in order to act as a deterrence. And of course, one of the big questions in respect of the truth recovery process is, because the proposal has a conditional amnesty, does that then fail to meet this necessary framework? So I'll come back to that in a moment. And then a second duty I've picked out, which seems to me to be absolutely key to the debate, is the second bullet point. The Article 2 imposes a procedural obligation on the state to carry out an effective investigation. So will the TRP constitute an effective official investigation? And if we could go to the next slide, please, Kayla. In our opinion, we've picked out through the various case law, there's a vast body, I should say, of case law from the European Court of Human Rights on this. And we've picked out indicia that of what would constitute or what is required for an effective official investigation from the case law of the Strasbourg Court. And it includes, firstly, prompt, reasonable expedition. Any investigation should be prompt and reasonably expeditious. Well, the TRP, obviously isn't in place yet, but if in place, there's no reason to think that it wouldn't act promptly and reasonably expeditiously. An investigation must be independent and impartial. And again, it seems to Kayla and me, as legal observers, as I say, not advocates of the campaign, but as independent observers, that it appears to be independent and impartial in terms of the institutions it proposes to create. Will it be sufficiently thorough and careful in its investigations? Well, in a sense, time could only tell in that respect, in terms of the success of any investigations that it would carry out. But as a framework, there was nothing to suggest to us that there was something that would be an obstacle to thoroughness and care on the part of those operating the mechanisms under the process. Another indicia, victims and family members of victims must, for an investigation to be effective and lawful, must have access to the materials and the conclusions of the investigation. And in this model, the TRP model, victims and family members, it seems to us, will not only have access, but they will actually be very involved in the process itself. The next bullet point, an investigation must be open to public scrutiny, and the TRP model appears to satisfy that. And then the final bullet point that we have, and this is potentially contentious, is it capable of leading to a determination of whether the death was caused unlawfully? We believe it can do that in theory, and if so, to the identification and punishment of those responsible. So we come back to this requirement, if it truly is a requirement of punishment. And of course, the conditional amnesty wouldn't, strictly speaking, satisfy that. So if we move on to the next slide, please, Kayla. The European Court of Human Rights has had some things to say about amnesties, but it hasn't actually considered a conditional amnesty, and I'll come back to that in a moment. But just to flag two cases where there's reference to impunity, amnesties, and the first one is a case that was brought against Turkey by the parents of a young man who was killed in a police station in Istanbul after being beaten by 4 officers. And you'll see his prison they were convicted, but the prison sentences that were imposed were suspended, fully suspended. And the Court of Human Rights held that this was in breach of the convention because it was comparable to a, quote, partial amnesty, since consequently the convicted officers enjoyed virtual impunity despite their conviction. And so reference there to a partial amnesty. And on the facts of that case, the Strasbourg Court held that there was a violation of the convention. And I might just underline before we move to the next case that a young man being beaten in a police station to the point of death engages under the European Convention on Human Rights both the Article 2 right to life and Article 3 of the Convention, which is the right not to be subjected to torture, inhuman or degrading treatment. And I should emphasize that the Strasbourg Court has said time and again that these two rights are among the most fundamental of rights and are absolute in nature. and they give rise to a range of duties, which I've touched on two of them in respect of Article 2. But that's the context in which the Strasbourg court held that there was a violation, the sacrosanct nature of Article 2, the right to life, and Article 3, the right not to be subject to torture, inhuman, degrading treatment. I'm going to come back to that in a moment, but I'd like to go to the next case, which is a case, again, where the Court of Human Rights considered in general terms amnesties. And this was a case, Margus against Croatia, and it involved the applicant had been prosecuted, but had been held to fall within a general amnesty that existed in Croatia. This was to do with there was you'll see in the first bullet point, there was a general amnesty in respect of the war there between August 1990 and August 1996, save for the gravest breaches of humanitarian law or war crimes. And Mr. Margus was charged, but his case didn't proceed because of the amnesty. But he was later charged again, and he was convicted. And he brought a case to the European Court of Human Rights to say that there was a breach of the principle in the convention, in one of the protocols to the convention, that you shouldn't be tried twice for the same alleged offence. And he failed in his case in Strasbourg. And the court looked at amnesties and considered the amnesty that had been in place in Croatia. They remarked in the second bullet point here, a blanket amnesty would, quote, run contrary to the state's obligations under Articles 2 and 3 of the Convention, since it would hamper the investigation of such acts and necessarily lead to impunity for those responsible. So I've mentioned Articles 2 and I've mentioned Article 3, torture, inhuman, degrading treatment, just a moment ago. So there's a clear statement here that a blanket amnesty would be unacceptable. However, and I should caution that it is a little bit ambiguous, but the court does go on to say, it appeared to accept that, quote, amnesties are possible where there are some particular circumstances, such as a reconciliation process and or a form of compensation to the victims. It's actually, I need to correct the paragraph reference there. It's actually 139. I'm sorry about the typographical error. If you want to look up the paragraph, it's paragraph 139, not 129. And the Court of Human Rights says even if amnesties are possible. So it is unclear as to whether, and I think it's a bit of a stretch to say that the court was definitely endorsing the possibility that an amnesty, endorsing very clearly that an amnesty could be lawful under the convention, but it certainly it does suggest that that might be the case. Now, to go to the next slide, and I've just 2 slides left. I'm nearly finished, but I want to now try and apply some of this to the TRP model. I've already made the point that the European Court of Human Rights has not looked at a conditional amnesty. And I want to pick out some of the particular features of the truth recovery process that led Kayla and myself to form the conclusion, in the absence of any very clear law from the European Court of Human Rights, that the model would be compatible with Article 2. Firstly, the purpose of the model is not to avoid impunity. It's not an amnesty in the sense of many amnesties that have been considered by international courts, which are amnesties brought in by a government, perhaps on the way out, to ensure that its own members or officials are impugned from prosecution. Its purpose isn't to avoid impunity. Its purpose is to try to establish the truth. And secondly, we think this is very important. It runs parallel to the criminal justice system. So it's not replacing it. It's not an amnesty in the sense that people cannot necessarily be prosecuted under the criminal justice system. The model allows an alternative to the criminal justice system if victims and their family members choose to opt into it, and they can withdraw from it during the process. And this seemed to Kayla and me to be a very significant feature of the model that would allow it to remain compatible with Article 2. And the next bullet point, victims and family members can shape the procedures and rules of engagement at mediation. The next point, the model allows for public scrutiny through the publication of joint statements. And finally, we asked ourselves, and I throw this out for debate this afternoon, I mentioned very early on in my presentation the importance of punishment as a form of deterrence. Well, these are legacy cases. And as I've already said, the model is reliant on people opting into it, including victims and family members. But in any event, as legacy cases, there's no suggestion that new offences would be dealt with under this framework. So how weighty is the need for deterrence in a truth-seeking project, a truth-seeking mission that goes back decades? And that's something that certainly I throw out for debate. I would be very interested to hear what everyone participating thinks. Now, just to move on then to the final slide, those are practical features that I've just raised among what Kayla and I thought were the key features. There are other aspects. We've written quite a long opinion, so I'm only picking out what I think are perhaps the most important points, and certainly points that are ripe for discussion this afternoon. That's really all I'm attempting to do in this 10 or 15 minute presentation. So I've looked at some practical features, and then the final slide is perhaps a little bit more legalistic. It's sort of looking at the focus as to how should the Strasbourg court look at this if it ever found its way to it. Well, the first point I'd make is that we are talking about the right to life, the right not to be subjected to torture and inhuman degrading treatment. My first bullet point, these are in the nature of absolute rights. There can really be no breach of these rights that can be justified by countervailing interests. So that's really a given. But just because that's the case, in my submission, it doesn't mean that all the duties that flow from the right are themselves absolute. So the duty to investigate and the duty that flows to prosecute where there's sufficient evidence is not really an absolute duty. I think the onus on the state would be to act in a manner that is reasonable in terms of investigation and prosecution. Then the second bullet point, member states have a margin of appreciation, and the Strasbourg court really the middle three bullet points all merge. In my submission, looking at legacy issues and the Irish and British governments and the Northern Ireland executive and community groups and everyone trying to work together to advance matters, it seems to me that in that kind of scenario, the Strasbourg court should allow a wide margin of appreciation. There are political and social dimensions that are at the core of dealing with legacy cases. And I would suggest that there should be very considerable deference from a supranational court as to any framework that is brought in with the majority support of the people. And of course, to finish on this note, the importance of victims' rights and wishes are absolutely fundamental. That's a given. But the model, it seemed to me in Kayla, and of course we'd be corrected by people on the ground if we're wrong on this, but the model appears to be aimed at accommodating victims' rights and wishes. And indeed, that's a key feature for the reasons I've said as to why we think the model can be compatible with Article 2. So look, I'll conclude there, and I really look forward to hearing everyone.
Michael, thank you very much for that presentation, delivered with your usual independence of mind, reassuring calm and attention to detail. So anyone who doesn't know Michael can see from that why he's such an effective advocate. So it's now my pleasure to introduce Kayla Varley BL, who will continue the presentation on the implications vis-a-vis the ECHR. Kayla was called to the bar in June 2019. She mainly practices in general civil practice with a particular focus on judicial review and administrative law. Originally from County Clare, Kayla is a lecturer in EU law and international human rights law in Griffith College, Dublin. She holds an advanced diploma in planning and environmental law and is currently pursuing a master's in disability law. And I saw Kayla in action very early in her first year at the bar, and I actually couldn't believe that she was just starting her career. She has a tremendous ability and presence that much more senior barristers would be very jealous of. And as I was astonished, absolutely astonished, that she was only in her deviling year when I first saw her, because she had all the skills and abilities of somebody very polished and professional in her career. So I would confidently predict considerable success for her in the future. So Kayla, over to you.
Thank you very much, Judge, for those kind words. Possibly a little too kind. I worry now you set the bar too high for everybody. In continuing on from Michael, I'm going to be very brief, and I'm going to make a number of distinctions between the truth recovery process, as explained to me in Michael, and the existing Stormont House Agreement and the new proposals that have been brought forward by the UK government this last July. And really, I should start out by reiterating that Michael and I were limited in carrying out this opinion, in that we were solely looking at the potential compatibility of the process as explained to us with Article 2 of the ECHR. That meant we didn't really have scope to examine the Stormont House Agreement in any great detail, or indeed the draft bill or the model implementation process, which has been brought forward. And similarly, we haven't examined the UK government's proposals in any great detail. And in fact, the most recent proposal was published in July of this year, so a couple of months after this opinion was finalised. The purpose of my presentation now is just to highlight some key points of distinction and similarity between the TRP as explained to us and those alternate proposals or alternate agreements. And as has been highlighted by Michael, by Liz, and indeed by Mr. Justice Humphreys, really the key issue of distinction between all three proposals comes down to the issue of immunity from prosecution or a potential amnesty from prosecution. Okay, so to look first at the Stormont House Agreement then. And Liz has already explained that the truth recovery process can be seen as, in some ways, coexisting with the Stormont House Agreement, and in some ways supplementing it or amending aspects of it. In particular, the key point to focus on here is the Stormont House Agreement's position on immunity from prosecution. So under the Stormont House Agreement, it is envisioned that any information gathered by the Independent Commission on Information Retrieval wouldn't be disclosed to law enforcement and would be inadmissible in criminal and civil investigations. However, that doesn't mean that a prosecution couldn't later ensue for that set of events, for an unlawful killing or for an injury, so long as the prosecution could proceed on the basis of other evidence. So we can see that the Stormont House Agreement really sees the information disclosed as part of the process as being inadmissible, but doesn't actually go so far as requiring or laying down any sort of immunity from prosecution or conviction. Similarly, then, we see a number of proposals which have been brought forward by the UK government in the last 2 years. The most recent proposal is that as set out in Command Paper 498 on addressing the legacy of Northern Ireland's past. And I suspect that we might have some discussion on this from the other panelists and members of the audience later. But essentially, this new Command Paper sets out 3 new proposals. So really quite clearly moving away from the Stormont House Agreement. The first proposal is that it would establish a new independent body to enable individuals and family members to seek and receive information about Troubles-related deaths and injuries. And interestingly, the proposal does envisage that there would be a possibility of face-to-face victim-perpetrator mediation. That would be at the initiation of the family, and it would be dependent on the consent of all parties to proceed. However, if you look at the proposal, it doesn't really seem like that's a central aspect to the Command Paper, rather something which could potentially happen if that proposal is followed. Okay. The most relevant proposal made from the Command Paper relates to the issue of immunity or amnesty from prosecution. And as many people on this call will be very familiar already, the Command Paper proposes to introduce a statute of limitation applying to all Troubles-related incidents, bringing an immediate end to all criminal investigations and prosecutions relating to the Troubles. The proposal seems to rationalise this on the basis that it would encourage people with useful information to come forward. And the argument seems to be that the trust in a truth recovery process will be enhanced where there isn't the possibility of an ongoing criminal investigation. Okay. So what does that all mean for our purposes today? We can contrast the Stormont House Agreement and the Truth Recovery Process proposal on a number of aspects. Under the Stormont House Agreement, there isn't any civil or criminal immunity per se. However, the information disclosed won't be revealed to law enforcement. That can be contrasted then with the TRP's proposal, which envisages a conditional immunity in respect of information disclosed on an unlawful killing that occurred during the Troubles. And as has been set out already by Michael, that conditional immunity is dependent on cooperation in the process itself. The TRP proposal could be initiated by a former combatant or by a perpetrator, not just by a victim or a family member. And the proposal envisions a restorative justice or mediation process as being really central to the entire proposal. Okay. To contrast the new proposals from the UK government then and the TRP, really the key difference here again relates to the idea of an immunity or amnesty. Under the Control Paper 498, we would see an immediate end to all Troubles-related criminal investigations through the introduction of a statute of limitations, as well as an immediate end to all prosecutions for deaths and serious injuries incurred in the course of the Troubles. And as Michael has set out, certainly in our understanding of the TRP process has been explained to us by the group, under the truth recovery process, there wouldn't be an end to criminal investigations because it would run parallel to the criminal justice system. And again, the immunity granted would be conditional upon cooperation with the process. Okay. All right, so I'm hoping that that has clarified our understanding of the TRP process to some extent, and hopefully has given us a basis now to discuss and debate the ideas going forward. Great, thank you very much.
Thank you very much, Kayla, for that excellent presentation and providing that very user-friendly comparison and presentation of the different options discussed. So it's now my pleasure to call on the first of our three other panelists to respond to the outline we've had from Michael and Kayla. And the first speaker responding to those papers is Bryce Dixon. And Bryce is Professor Emeritus of International and Comparative Law at Queen's University Belfast, and was Chief Commissioner of the Northern Ireland Human Rights Commission from 1999 to 2005. He's been a prolific author, and his latest book of very many is The Irish Supreme Court Historical and Comparative Perspectives, published by Oxford University Press in 2019. Bryce is also, in a possibly somewhat loose sense, a colleague of mine in my very ephemeral capacity as currently a visiting scholar at Queen's University Belfast Law School. Bryce has been a consistent voice of reason and moderation in the very fraught world of Northern Irish law and political debate. And unlike many, he's committed to seeing both sides of problems, building on the common ground and developing relationships. But all that said, he's quite prepared to state less fashionable opinions when the need arises. And overall, Bryce is really the nearest thing Northern Ireland has to a national treasure. So it's my great pleasure to call on Bryce to continue this afternoon's discussion. Bryce.
Thank you very much, Richard, if I may. That was a compliment too far, I think. Let me start by paying tribute to Pádraig Yates and his colleagues for devising and campaigning for the truth recovery process. I'm afraid I don't share their optimism that the initiative will in the end prove effective, but I do applaud their efforts in contributing to the debate on how best to deal with the past in Northern Ireland. And in the few minutes at my disposal, I'm going to critique the TRP from the point of view of Article 2 of the Convention, and in doing so will focus on the legal opinion which Michael and Kayla have recently outlined. That opinion valiantly argues that the TRP satisfies the requirements of Article 2, and in doing so it takes into account the jurisprudence of the European Court of Human Rights and also the more general standards of international law relating to victims, such as the EU Directive of 2012. My view, however, is that while the TRP does not actually violate Article 2, it does not fully comply with it. And this is because, despite the arguments contained in the legal opinion, the process envisaged by the TRP does not meet the minimum standards of investigation which a state must provide when there is an unexplained death or injury. And I suspect the authors had some concerns about that point themselves, because in the introductory paragraphs of the opinion, they say that the TRP complies with many of the requirements for an effective investigation. Many, but not all. And the two, I think, which it most does not comply with are the ones requiring public scrutiny and requiring an investigation capable of leading to the punishment of a perpetrator. The Irish government's position, by the way, is that there should be effective investigations into all troubles-related deaths. I also disagree with the opinion writers when they say that the TRP ends impunity and achieves deterrence. if an amnesty is to be provided for information supplied as part of the TRP, it's not clear to me why that is not impunity. And the opinion writers suggest that the actual process itself, although initiated by a former combatant, could constitute a penalty or punishment for the alleged perpetrator. But with respect, that seems to me a rather perverse conclusion. More broadly, I don't think the TRP does anything to fulfill the purpose of an Article 2 investigation, which, as the authors themselves point out, is to secure the effective implementation of the domestic laws safeguarding the right to life and the accountability of state actors and bodies for deaths occurring under their responsibility. Far from implementing domestic laws and holding the state to account, the TRP ignores domestic laws and potentially lets the state off the hook. The authors counter this by claiming that even a flawed investigation may comply with Article 2. But for this, they cite the McCann case in 1995, which preceded by 6 years the European Court's clarification in the McCare case of what actually is required for an effective investigation. Insofar as the McCann case suggests, for example, that an inquest can by itself be enough to comply with Article 2, that is clearly no longer what the European Court believes. The authors of the opinion appear to accept the European Court's position that an amnesty should never be granted for torture. So it's difficult to understand why they believe that the court would approve of an amnesty for something even worse than torture, namely murder, and how the TRP would deal with a case where a victim was tortured before being murdered, as was often the case when the IRA was dealing with so-called touts, is unclear. The TRP also seems to fail the test for compliance with Article 2 by allowing it to be triggered mainly by former combatants or perpetrators. The legal opinion suggests that victims can trigger it too, but I'm not sure how that would work if relevant perpetrators are unwilling to give information to the proposed justice facilitation unit. And the European Court is adamant in saying that Article 2 investigations must be initiated by the state, not by anyone else. And if it is argued that a legal agreement between the UK and Ireland adopting the TRP could be incorporated into the domestic legal systems of the UK and Ireland, that of itself would not satisfy the requirement that investigations in individual cases must be initiated by the state. Remember that the TRP's Truth Recovery Unit has a role only to verify information received by the Reconciliation Commission, not to proactively assemble evidence for a prosecution. The legal opinion sets great store by the fact that the EU's Victims Directive has been made part of the law of Northern Ireland through the Victims Charter in place since 2015. But that Charter, A, is entirely supplementary to, not an alternative for, the ECHR, and B, it is not legally enforceable through the courts of Northern Ireland, except perhaps indirectly through judicial review proceedings. The Charter speaks throughout of victims' entitlements, but it does not, in fact or in law, confer any statutory rights. Nor does the Victims' Charter use the word reconciliation even once. If the TRP model is implemented, it will end with a joint statement of reconciliation between a former combatant and a victim or survivor. To me, this is a misuse of the word reconciliation. The statement issued may be a joint acceptance of what in fact happened many years earlier, and perhaps even why it happened. But it will not necessarily represent, and it should not automatically be construed as, an acknowledgement by the victim or survivor that they are reconciled to what occurred. In fact, after the TRP, the victim or survivor may hate the perpetrator even more than before. To go further then, as the TRP does, by encouraging the parties to a joint statement of reconciliation to engage with others in order to promote greater understanding of the nature of the conflict in Northern Ireland is, I fear, a step too far. And without any such public engagement, Article 2's requirement for investigations to be subject to public scrutiny would not be met. Now, despite all that I've said, I am myself in favour of testing the willingness of the European Court of Human Rights to accept a truth and reconciliation process in Northern Ireland. And as Michael rightly pointed out, there is a hint in the court's jurisprudence in the Marcus and Croatia case that the court might be prepared to accept some kind of amnesty if this is provided for in the context of a wide-ranging agreement to deal with a difficult collective past. To me, essential ingredients of such a package would be, first of all, a good compensation scheme for survivors of the conflict. And thankfully, we do now have such a scheme in place. Second, there should be an agreement by all sides to the conflict to acknowledge the wrongs that they committed and to pledge to work to remedy them. And thirdly, I think there should be a vote by the people of Northern Ireland and perhaps by the people in the Republic as well in favour of terminating all police investigations into and prosecutions for troubles-related deaths and injuries. Any such referendums would supplement those which took place in the wake of the Belfast Agreement in 1998, which itself provided for particular kinds of amnesties. If the people of the island collectively endorse a truth and reconciliation process proposed by all sides to the conflict, then I doubt very much if the judges in Strasbourg or the committee administrators there would stand against it, notwithstanding the many still unresolved issues, such as those in the McCare group of cases, which includes, of course, the case of Pat Finucane. I'll end with that, Richard. Thank you very much.
Thank you very much, Bryce, for that characteristically excellent, penetrating and challenging contribution. It's now my pleasure to call on our next speaker, Pat McCartan. Pat McCartan has had 3 outstandingly successful careers, first as an extremely busy and active solicitor in private practice in Dublin. In parallel with that, he was a public representative and ultimately a member of Dáil Éireann for Dublin North East. And finally, was a long-serving and very hard-working and very successful judge of the Circuit Court. He's now on his 4th act, and I'm sure that he has much left to contribute. So on that note, it's my pleasure to call on Pat as our next speaker.
I'm very heartened by the particularly incisive words of Bryce Dixon in analysing the shortcomings, perhaps, of the proposals set out. But I'm very equally heartened by his concluding remarks, where, frankly, I don't see anything else being proposed. The British government would seem not to know its own business and where it's going with all of this. And the principles and ideas set out in the programme that the campaign has put there are consistent and are attempting to address what seems to me the present situation in Northern Ireland. And we can't forget the statistics that are there and the impossible task of asking the British government, the Northern Ireland resources, and all of the police forces involved to meet the kind of demands that are sought under Article 2 for effective investigations. In short, I think that day is past. And there is so many unsolved murders to be looked at, to be addressed, injuries, so much damage done that there has to be an effective way forward. And frankly, I believe what is being proposed by the Truth Recovery process is perhaps the most realistic at this point. I very much support the idea that the process must be extrajudicial outside of the litigious process, be it criminal or civil. It has to be dealt with in an informal environment that is pursuing a non-litigious path to an effective resolution of some of the hurt and damage that still persists. In regards to the question of amnesty and that question that has been central to the opinion and the discussion so far, I don't believe that we have looked carefully at the issue of the elapse of time and of the particular circumstances that now exist in Northern Ireland. And I think I would have great confidence in, if there was a challenge to be taken to a process similar to what's been suggested here today, that the European Court has the capacity and scope to recognise and respond to what is being suggested here. It's a point that is made in some of the documentation that in other European jurisdictions, for instance, there are time limits to the prosecution, even for murder. And if one was to apply some, if not all of them, to the Northern Ireland situation, all of that would have passed by now. And I ask on the other side of that, what is the reasonable prospect today of the state in Northern Ireland, Great Britain, ever meeting the obligation set out under Article 2, which is undoubtedly there, at this remove to provide effective examination? I don't believe it's there, or effective investigation. And the question of punishment is well past. So in those circumstances, I believe that what's been now proposed and suggested is an effective and useful mechanism, and one that we should pursue with all vigour. Thank you.
Thank you so much, Pat, for that valuable contribution and perspective. It's now my privilege to call on Alan McBride as our final speaker on the panel. Alan's life changed forever when his wife and father-in-law were killed in the IRA bomb attack at Frizzell's fish shop on the Shankill Road in Belfast. His initial response was one of anger, but he now views the Troubles as a tragedy that could have been prevented if people would agree to live and let live. Today, he's a peace activist and a victims campaigner, and he manages the Wave Trauma Centre in Belfast, where he led the Wave Injured Group in its campaign for pensions. Representing relatives and survivors is so vital and central to the whole debate that it's really important and welcome that we have Alan here today. So I now hand over to Alan as our concluding speaker. Alan.
Okay, thank you, Richard. I suppose as I was listening in, I became aware that I'm probably the only one on the panel with no expertise or anything to bring to bear within a legal framework. So my comments are going to be very much borne out by my I suppose my own personal experience as a victim survivor of the Troubles, but more importantly, by the work that I've been doing over the past 20 years with victims and survivors. As I was reading through the Truth Recovery process, I was thinking actually about a conversation that I once had with Alex Borean, who was the deputy chair of the Truth and Reconciliation Commission in South Africa, and now passed away. And he was in Northern Ireland in 1999 to meet with various NGOs, politicians, community activists, victims and survivors, former paramilitaries, police officers, etc. And he came up with the report, All Truth is Bitter. And I suppose really it was him who I first heard talking about the inadequacy of the judicial system to actually deal with the conflict. He was also talking about it being expensive and about it being not particularly geared up for victims and survivors, that it was adversarial and all of that. So And of course, because of his experience within the South African Truth and Reconciliation Commission, no doubt much of what is in this report is probably, or would have been certainly music to his ears. But, you know, that was back in 1999 when I met him, and this is now, of course, 2021. And it seems like we've been having a very, very, very long conversation. And sometimes, maybe to quote Greta Thunberg, it probably sounds a wee bit like bloody blah, 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 sometimes, because it just seems to go on and it goes on and it goes on. And of course, during that time, there's been countless initiatives, and I've been involved in many of them, right back to 2002, when I think the first report came out into how we should deal with our past regarding truth, justice, and acknowledgement, which was the Healing Through Remembering report. And then we had the ELOS report, which was a report by some of the nationalist groupings that looked into truth recovery. Of course, we had Eames Bradley, Hass O'Sullivan. We've had the Historic Inquiries team, Stormont House Agreement, and more latterly, the Fresh Start Agreement. And it seems to me that every time we go back to the negotiating table or to a round of consultations, we come out with something considerably less than what we had before we went in. But I will say that, you know, a lot of them have had certain similarities, and they had certain principles. And I also see that in these recommendations as well. And of course, the first and foremost one, I think, has to be that whatever process is put in place is victim-centred. I think that is a given. I think that was why there was so much hurt, for example, expressed by victims and survivors whenever we had the Lambeth Palace talks just last year, which you know, didn't include any victims and survivors organisations, but was basically British armed services and paramilitaries talking amongst themselves. And I think that certainly at the time was a slap in the teeth. But, you know, even looking at this process, and you know, and I've read that, you know, it was a sort of a combination of you know, former paramilitaries and academics and victims and survivors. But I don't know how many victims and survivors you actually spoke to, just to see how much of that was actually included in shaping the thinking. The other thing, I suppose, is that there has to be absolute trust in the process. And I think for victims and survivors, trust is largely absent in many respects, and probably because and oftentimes they haven't actually really been consulted, or if they have been, it's been sort of tick a box exercise and more tokenistic. I think there has to be a continuity of care. You know, I think whenever you get into this process, you have to be in it for the long haul. And one of the things, I suppose, when I was reading through the documents, there doesn't seem to be a time frame mentioned, or if there was, I must have missed it. But I think there has to be some kind of an idea of how long you're in it for, and what the continuity of care is going to be. I mean, one of the things with the HET for victims and survivors was that quite often, you know, victims and survivors felt as if they were being passed around from pillar to post. Where if you were to contrast that, for example, with the Canova model, which we've been very involved in, you have officers there that have come and that have, you know, worked with Canova and that have really gone the distance with the families. And I think that has really paid dividends, in that there's 31 prosecutions now with the Public Prosecution Service. And I think there's a very high satisfaction rate. Certainly, Alison Kirkpatrick's report would have borne that out with regards to some of the families. The other one then is in relation to truth and justice. And I suppose, you know, when it comes to amnesty, because of course the government's latest proposals with the statute of limitations is more or less a blanket amnesty. And I suppose one of the things, I suppose, that I'm glad to see in this report is that, you know, you at least have acknowledged that, you know, that there needs to be a trade-off between truth and justice. You know, so the amnesty, if there's going to be an amnesty, needed to be conditional. I mean, I remain to be convinced about just what that will mean, and what sort of answers it will bring forward for families. And I would like maybe to explore a little bit more about what is meant by the term professional civilian investigators, because I would have thought that, you know, people who were investigators would have had to come from the police family somewhere. They may not necessarily be members of the RUC or PSNI or indeed the Garda Síochána, but I do think they have to have had an investigative background, and that would mean being some part of the police and family. If you were rewiring your house, you wouldn't ask a plumber to do it, for example. So I suspect that I need to maybe look into that a wee bit more. With regards to the document itself, then, I mean, I suppose I do see, and I share some of Bryce's concerns. I do see a number of shortfalls within it, and I just probably name the first two, which I think are going to be huge hurdles to get over. For anything to happen is going to need, I think, cross-party support. And I don't know if you have tried to get that cross-party support for this, or is that the next step? I mean, most parties, with maybe the exception of the Ulster Unionist Party, are very much holding to the Stormont House Agreement as the way forward. And I don't know if there's a way around that. The other big issue then, of course, is the size of the Tory majority and whether or not you can get them to listen. I've met with them several times in relation to the command paper, and they assure me that they're in listening mode. And if they were indeed, as they're claiming to be in listening mode, then I think it's pretty much a foregone conclusion that their recommendations will not be taken on board, because everybody they've spoken to, political parties and NGOs, have told them that their current proposals are wrong. I actually was at a meeting on Monday when with some academics from Queen's University School of Law, and they were saying that the command paper, their proposals for a statute of limitations, was actually worse than Pinochet's amnesty in Chile. Again, I'm not a legal person. I don't know how valid that is, but that was certainly what they were saying. Just a few things to finish on. I think it was someone said, the last speaker said about there being no other proposals on the table. And I don't know just if that's true, to be quite honest, because the meeting I was at on Monday was with the model bill team from Queen's University and the Committee for the Administration of Justice. And they've come up with a number of proposals. One that they're coming down quite forcibly on is that that there would be an investigation, but that the people at the end of it will serve no jail time. So perhaps it's not that dissimilar from what is being proposed here, but that's definitely another proposal. I've also met with the Methodist Church, who've got a series of proposals, and of course we're working very closely with Canova, which is also being advocated as a way of doing this. And then of course you have in itself the Stormont House Agreement with the proposals contained within it. The other thing I suppose that I would say, and perhaps my biggest criticism of this process, is in relation to this, that it seems to be built upon a power imbalance. And in my view, as a victim and survivor, and as someone who works with victims and survivors, when it comes to truth and truth recovery, it seems to me that the perpetrators hold all the cards. And I think that if you're going to get to the truth needs to be interrogated. So when I was reading that, that this process wouldn't be assembling evidence that was going to be, given over to a court for prosecutions, but more or less what they were doing was trying to establish the truth. Well, I suppose the question I have is whose truth and how do you interrogate that truth? I was very proud to stand very recently with the Ballymurphy families after Justice Keegan gave her findings into the inquest into the events of Ballymurphy. And of course, the official version, the perpetrator's version of what happened on that day, was the British Army's version, which was that there was gunmen and gunwomen on the streets of Ballymurphy in 1971, which resulted in the deaths of all of those people. But when it was interrogated and when the truth was explored and investigated, of course, it came out that none of them were armed, that they were all civilians, mothers, fathers, sons, brothers, who were there. Some of them looking for their children who were actually running about in West Belfast because there was the commotion going on. But if we had left it up to the perpetrator to have the last word, that's not what we would have gotten, and that concerns me greatly whenever you're getting into this process. And I know that you're saying about there'd be a joint statement of reconciliation. And I suppose I also concur with what Bryce was saying about that. Even if you got an agreed statement of what happened, the fact that that's going to lead to reconciliation, I think, is a bit of a stretch. In fact, even if you got an agreement of what happened, I think that also is a bit of a stretch, and you could indeed end up hitting the perpetrator even more than you did before the process began. You know, the last thing I'll say is this, with regards to, you know, the conditional amnesty, which was a sort of a central tenet of this process. And that has to be tested about whether or not that will actually work or not. And I'll have to say to you that in my experience as having worked in WAVE for over 20 years, and part of our work has been with the families of the disappeared, and you'll know that there is an amnesty in place for people that have come forward and given information about the whereabouts of victims' remains. But I have to say that has been a long and an arduous process where the information has trickled out at times, where families have practically had to beg. You know, if it wasn't for the families and the work of the victims commission in terms of the location of the remains, a lot of information just quite frankly wouldn't have come out. And given that there's 3 bodies left, Clonmel McVeigh, Robert Nairac and Joseph Linsky, and that we are still looking for information, even with the amnesty being put in place, and the fact that people are still not coming forward and telling the truth or telling where those victims are buried, would suggest to me that, you know, that this notion that we'll have a conditional amnesty and all of a sudden it would encourage people to come forward and tell the truth might actually not work out in practice. Can I just say one thing just before I go on? We can then open up the conversation. I think one of the things that concerns me most about all of this, and I think goes maybe back to my comments about the blah, blah, blah thing, is that, you know, we're running out of time. And I think that really has to try to concentrate minds. Just in the past 2 weeks, we have buried 5 of our members here. On Monday there, I was speaking at this thing up at Stormont, and my boss Sandra Peake was to speak at it, and she couldn't be there because she had to attend the funeral of Patsy McAteer. Patsy McAteer was Seamus Ruddy's sister. Seamus Ruddy was one of the disappeared, and Patsy was just the latest in a long line of victims and survivors that have passed. As I say, in the last 2 weeks, we've buried 5. So one of the concerns I have about this is that whatever happens next has to happen pretty fast. I think we absolutely have to stand you know, firm in the face of these British government's proposals, because I think they are draconian, I think they are wrong, I think they are immoral, and we need to face them down. But whilst there's no agreement out there, because you have the model bill team doing their thing, you've got Canova doing their thing, you've got this process doing its thing, you've got the Methodist Church doing their thing, whilst there remains no agreement between all the other players, the NGO sector, the political parties or whatever, then I think you give the British government an out. And one of their arguments is that there's no agreement on how we deal with this stuff, so this is our best take on it. And that is why I think they're pressing ahead. So I am concerned, very concerned, and I think it's about time that the sector got together. And maybe at Stormont House, maybe that's the thing that most people can gather around. But I see you guys have been quite critical of that in favour of this process. So that's all I have to say, really. Thank you.
Thank you very much, Alan, for that really crucial perspective. And if you'll allow me to do so, I would congratulate you on your personal courage and dedication and your tremendous work towards peace, and on behalf of those who have suffered in the Troubles. So thank you very much again for contributing. So I now want to go over to Professor Catherine O'Donnell of UCD's Centre for Ethics and Public Life, who's going to identify 1 or 2 of the questions that have come in on the chat function, and we will go back then to our panelists to see who will be able to respond. Catherine.
Thank you, Richard, and thanks to everybody for coming on this Friday afternoon. The conversations have been so rich. I've just opened up the question and answer function so that everybody can see the questions and comments that have been asked, and as we won't have time to discuss even a large fraction of the questions, please feel free to type answers and comments to each other's questions. I do think because Brian Walker, formerly of BBC and UCL Constitution Unit, was first, he's asked a question that picks up on many of the issues that other people have raised too. So I'm going to put that one first to our panel. Could the TRP work alongside continuing judicial process of some kind, as most parties envisage? Other people too have mentioned restorative justice measures. What are the incentives for former combatants to take part in the TRP, which he assumes would include state actors?
Okay, thanks very much, Catherine. Well, I think as that might be a question about how this particular model would work. Would Pat maybe like to tackle that one, or one of the other members of the TRP group?
Yes, I mean, David Clemens also wanted to put a question particularly to Pat.
Yes, okay. Well, why don't we get two for the price of one? Okay.
Yeah, an extrajudicial process. What's the chance of such a way forward when there's so many lawyers in the room?
Okay. Right. Now, Pat, you'll have to answer that one on behalf of all of us.
I realised that I emphasised the fact that I was speaking as a lawyer. And I do strongly believe that the process needs to be outside of the courtroom, effectively. I'm prompted in that because there is some suggestion that there is another proposal being mooted, the detail of which Padraig Yates would probably be the better person to give you more about, where there's a talk about giving to the victims the right to initiate civil litigation, and in pursuit of those civil litigations to be given access to state information or state confidential information. I'm not quite sure where that's coming from or who's proposing it, but it is an idea that has been suggested. My view personally is that that the lawyers and all of us, I think, have to take, to repeat this, cognizance of where we are today. And it's echoing a lot of what Alan McBride said, that we're running out of time, or we are so far removed from the realities that we just simply have to admit at some point there is no real prospect of an effective investigation from, for instance, a police criminal law pursuit. And it's to look for some other way to help victims primarily, and combatants where they want, to in some way reconcile, in some way to move forward. It's not a perfect system by any means, but if you were to look at the statistics of what has been achieved or not been achieved by criminal investigations to date, there are something in the order of 1,700 items that unsolved murders alone. And of the more recent investigations, of the 33 legacy cases, 17 prosecutions, and out of that, four convictions. I mean, it's such a small return to look at the statistical level of it. So I'm simply driven by the view there has to be another and more effective way.
Okay, thanks very much, Pat. Since you mentioned Padraig Yates there, Padraig is also on the call.
There's so many points; it'd be impossible to mention them all. One thing, for example, I very much welcome was Bryce's suggestion that if whatever comes out of whatever process we end up with, it should go to a referendum, and it should go, I think, on both sides of the border. And we shouldn't forget Britain either, because some of the most neglected people in terms of victims are people in Britain. I've had a few conversations with Alan, and no doubt have more. He's absolutely right about time. I'm 75 years of age. I can remember the beginning of the Troubles. A lot of the people I knew in 1970, 71, 72 are dead, including people who are former perpetrators or combatants. We prefer to use the term combatants because if you don't use pejorative terms, you start the conversation on a better basis. But I think we have to look at this as it wasn't just a crime spree. It wasn't just some people losing the run of themselves, although that certainly happened as well. But it was people in communities who thought they were doing the right thing. They were either defending their community or they were advocating or promoting a particular cause they believed in. They didn't go out to do these things, the vast majority, in my opinion, intending to do the sort of harm and cause the mayhem that did occur. One thing, I was at the Ballymurphy inquest briefly, mainly to discredit something that a document that I had a hand in. But what amazed me at that was the total failure of the inquest as a body, as an adversarial process to establish exactly what happened that day, because it didn't. And the trouble with all of these court cases is they focus on particular facts. They focus often on particular testimony, and it is the job of the advocate, whatever side they're on, to either support the testimony of somebody giving evidence or to undermine it. So I think there's a lot of flaws in the current system. We have to find a way forward. Time is running out, and Canova is mentioned, over 30 prosecutions possible, possibly, but I've heard from sources in there that it might be a lot less than that. And on the question of investigators, trained investigators, I have no objections, couldn't have any objections to police officers carrying out investigations. But police officers are trained to assemble evidence for a prosecution. They're not trained to assemble information to give a full picture of what's happening. What I'm trying to say, I suppose, in a long-winded way, is we have an ethnographic conflict here based not just on generations, but centuries of two different identities in the North. We cannot solve this problem by dragging cases individually into the courts, because eventually we'll run out of time. The one thing we won't run out of are transgenerational victims. We won't run out of people who suffered, or whose parents or grandparents or great-grandparents suffered. I was talking to someone earlier this week who was referring, and got quite emotional, and I could understand why, to relatives of theirs who were killed in the earlier Troubles in the 1920s because of a tradition that and information that had been passed on to them. So my plea is that we have to find some way of approaching this. I'm very unhappy about the CAG proposal, because that, to my mind, brings the criminal justice system into discredit. It's basically saying if someone gets in the dock and says, I'm guilty, there's a sentence passed that they murdered someone, and then they're allowed to go free. That, to my mind, is a total travesty of what should be justice. I think our system is better. So I appreciate I've gone on a bit too long, but time is of the essence. We have to find a way of doing this, and it has to be done very quickly. People I know who had valuable information have died. COVID hasn't helped in that regard either, because many of them are people of my age who would tend to be more vulnerable. So urgency is of the essence.
Thank you very much, Borg. Catherine, we've probably time for one more question.
Yes, there's again, I did encourage people to type answers and get involved in the Q&A chat box. There's some questions that are skeptical of the Stormont House Agreement as a structure we should be concerned with talking about, as it hasn't been implemented properly, and also some worries about the ECHR group. But I'm going to just come to a question from Peter Sherlow, specifically to Bryce around his idea of referenda. And he wants to know if Bryce believes that such a vote would change ideological assertion and develop conflict transformation. So he's interested in the way in which we are caught between ideologies or narratives of apologies and humiliation, and thinks that the space for challenging that is in Bryce's idea for referenda.
Okay, Bryce, I think that's one for you.
Thank you. Well, what it would do, I think, is get round the political impasse we have in Northern Ireland at the moment. There is no political party that's willing to go into an election in Northern Ireland saying that a line should be drawn under investigations and prosecutions, because they know that's not what the victim community want. And while two or three of the speakers today have rightly said that victims' interests are extremely important and should be taken into account, we have to face the uncomfortable fact that the vast majority of people in Northern Ireland do not carry victimhood with them. And my view is that, like it or not, a majority of people in Northern Ireland want to draw a line under the past, not to forgive and forget, but to draw a line under the justice system's involvement in the past, because they want to get on with spending money and time on current and future issues, not things that happened 40 or 50 years ago. That's uncomfortable to say, but I think it's the reality. The Good Friday Agreement was put to a referendum. Nobody challenged it or subsequent provisions relating to it in the European Court of Human Rights. So the location of victims' remains commission, the decommissioning of weapons, the early release of prisoners, all of those potentially breached human rights, but nobody challenged them in the European Court. And therefore, if there's a referendum endorsing drawing a line under prosecutions, etc., I don't think that will be challenged, or if it is, it'll be an unsuccessful challenge.
Bryce, thanks very much indeed. Well, we are somewhat running out of time. I don't know whether, I don't mind if you want to squeeze in one more question.
Just to take one from Claire Hackett. She's just wondering about the resistance to implementing the Stromness Agreement, particularly from the British government's point, and also resistance to the consultative group in the past. She's questioning that the TRP proposal seems to be designed to be acceptable to the British government and wonders, has this been key to the thinking?
Yes. Okay, well, maybe what we might do is perhaps if we end on that very practical question.
We have met with the NIO. We have met with the Department of Foreign Affairs. We haven't had a lot of meetings with them. We're glad to have the meetings, but there's no question that neither of them were endorsing what we were doing. No, I mean, this originated basically with one or two former combatants saying, is there anything we can do? That's where it came from. Those people came from both sides of the divide, Republican and Loyalist. So that's where it initiated. Some of these people would have already served time. Some of them served time for things they didn't do, by the way, and didn't do time for things that they did do. So this is very complicated. And I think that's the miscarriage of justice issue is very important, that not only is it a miscarriage of justice for the person who did time for something they didn't do, it's a miscarriage of justice for the families who think they got justice, and they didn't. The criminal, I believe strongly that the criminal justice system is not geared to deal with communal conflict. It's not what it was designed for, and it doesn't work. And the living proof of that is that 23 years after the Good Friday Agreement, we're talking about this all over again.
Well, Padraig, thank you very much indeed. So can I now thank everyone who contributed and hand back to Danielle for a few closing remarks. Thank you very much.
Thank you so much. And sincere thanks to you, Mr. Justice Richard Humphreys, for chairing this event so well today. We are getting a lot of comment in the questions about people either not being able to see the questions or the fact that we have not been able to address many of those questions. We are capturing the questions and we will attempt to share those questions in some manner after the event. This event is being filmed, as we mentioned, so we will try and offer some way of seeing those questions afterwards. But for now, I'd like to extend a sincere thanks to all of you for attending today, and also particularly to the panellists, Michael Lynn, Kayla Varley, Bryce Dixon, Pat McCarson, Alan McBride. I'd also like to suggest that if you'd like to be made aware of forthcoming events, more of these sorts of events, to email the co-hosts of this event or the Truth Recovery Process. One Truth Recovery Process event to mention is the forthcoming launch of their e-zine, Legacy Matters, by Paddy Hart, Chair of the International Fund for Ireland, which will take place on Friday, December the 3rd at the Linen Hall in Belfast at 12:45 p.m. And Alan McBride will also be speaking at that event, I understand. You do need to let Linen Hall know in advance if you do want to attend, because space is limited, particularly due to COVID. And you can also find more information, as you can see, from the websites provided now on your screen, including not only the Truth Recovery Process website, but also if you would like to be provided with more information about the activities of the three centres or institutes that are hosting this event, the UCD Centre for Ethics in Public Life, the Centre for Cross-Border Studies, and the Institute of Irish Studies, University of Liverpool. Our website addresses are on the screen now. So we do encourage you to contact us if you'd like to know more about forthcoming events. So it just remains for me, on behalf of the co-hosts, UCD Centre for Ethics in Public Life, the Centre for Cross-Border Studies in Armagh, the Institute of Irish Studies at Liverpool University, to thank everybody for attending today, and particularly to the very rich discussion that we've heard from all the panellists and from the legal opinion that we heard, which is incredibly important to have this discussion. And we're very honoured and wish to extend a very warm thanks to our Chair, Justice Richard Humphreys, for chairing this event today. And thank you so much once again to you and to all the panel members. Thank you, and we hope to see you at the next event. Bye for now.